Why do we have all these foreign-born judges on the American federal bench? Does America, a nation of over 300 million people, not have the capability of producing our own natural-born citizen federal judges with lifetime appointments? We have a Canadian-born judge ordering about our Article 2 executive branch, democratically elected president, commander-in-chief, and his subordinate officers. Why is that?
That individual, as you said, was armed with a semi-automatic weapon. So that was 2 from a couple of days ago. Today, more of the same. Another semi-automatic weapon in the car of an individual that tried to box in a Border Patrol agent. Sean, we've seen more weapons here in Chicago in a month than we did in Los Angeles over a 4-month period. Definitely something going on here in Chicago.
Dictatorship update, liberal, Canadian-born, to Jamaican parents. Judge Sarah Ellis forces top Border Patrol official Greg Bavino to physically report to her each day on his work in Chicago to ensure he isn't doing anything wrong. No finding or adjudication that Greg Bavino or any of his officers have done anything wrong. There's been allegations from the media that lies to us every day about what immigration is doing and what these illegal migrant third world invaders are doing. Sarah Ellis, born 1969, London, Ontario, Canada, to Jamaican-born parents. She didn't become an American citizen, a naturalized paperwork American citizen, until she was 15 years old. Raised to the federal bench, nominated by, of course, Barack Obama. She says if Border Patrol are naughty boys, she's going to take away their tear gas. Zero demonstration that any of this tear gas or any other use of force by Border Patrol has been inappropriate in any way. Again, just a reminder, born in Canada to Jamaican parents. A Kamala Harris on the federal bench. Sean Davis writes, this is absurd. We now have federal judges demanding that executive branch employees get daily pre-approval on things like uniforms and badge locations from unelected black-robed, tyrannical, inferior district trial court judges. I was asking myself, if the judiciary became tyrannical, in what way would it be acting any differently than this judge, than all these judges? The lies, the lies, the lies. In a new filing today, plaintiffs, the news media, accuse immigration agents of new violations of Judge Sarah Ellis's restraining order limiting the use of tear gas on protesters. They say Commander Greg Bavino lied about getting hit in the head by a rock. Of course, we actually have video of it happening, of the rocks being thrown, flying past Bavino's head, and of course, he doesn't actually have to be struck in the head, although he says he was. The use of tear gas to prevent lethal force against Bavino and his men is well within the legal boundaries. It's even well within the rules of the Judge Sarah Ellis TRO. And we know we can trust the media, right? Because the media reports like this. Federal agents arrested an undocumented father at his home in San Jose while he was on his way to work. On his way to work. Oh my gosh. Oh my gosh, get Judge Sarah Ellis on the phone. Except, of course, this undocumented father on his way to work, an illegal criminal alien from Mexico in our nation, criminal record for lewd and lascivious acts with a child, domestic abuse, domestic battery, paying for prostitution, and felony reentry after he's already been removed from the nation. This is the same media whose side Judge Sarah Ellis is taking. She believes them. She believes them. She never questions any of their claims about the federal government. She just doubts the federal government. That's weird. What about the duty of candor of the plaintiffs and their lawyers to the federal court, Judge Ellis, when it's demonstrated they're lying to you again and again? By the way, the plaintiffs are violating the TRO. The plaintiffs, before they file an alleged complaint about the TRO, are supposed to reach out to the government first and ask, hey, what happened? Is there a reason you used the tear gas? But the plaintiffs don't do that as required by the TRO. They just run right to court so they can get more headlines, give Sarah Ellis another opportunity to grandstand. And she is full of grandstanding. It is unbelievable. As we look at this transcript, you will see that there's nothing Judge Sarah Ellis likes as much as hearing herself talk. It's supposed to be a questioning of witness Gregory Bovino she's ordered in front of her court, but she talks and talks and talks and talks and talks. You know, she says, when I was getting ready for this morning, and you won't believe how long she talks before Bovino gets a word in edgewise. You know, when I was getting ready for this morning, I took a look at the oath that I took and the oath that you took when we both started our jobs. And the oath I took says blah, 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 blah. And the oath you took says that you solemnly swear that you will support and defend the Constitution of the U.S. against all enemies, foreign and domestic, that you will bear true faith and allegiance to the same, that you will take this obligation freely and without any mental reservation or purpose of evasion, and that you will well and faithfully discharge the duties of the office in which you are about to enter. She's going to take this oath, Judge Sarah Ellis, and say, that gives me the authority to micromanage you without any adjudication that you violated this oath in any way. We both agree to support and defend and uphold the Constitution and the obligations we have under the Constitution. And as a member of the executive branch, you have a different role to play than I do. Just she doesn't hesitate to micromanage him. And my role is not to tell you that you can or cannot enforce validly passed laws by Congress. But she is going to micromanage his ability to do exactly this. That's not my role. And I have no intention of doing that. She's doing exactly that. This two-faced little judicial hypocrite. My role is simply to see that in the enforcement of those laws, that you and your agents operating under you are acting in a manner that's consistent with your obligation under the law. Meaning that it's consistent with the Constitution, that it's consistent with federal law. You would think that this judge runs Border Patrol. How is this her job? This is not her role. It's not her role. There's been nothing adjudicated that Border Patrol has done anything wrong. It's not her job to micromanage how Border Patrol does their job, how any executive branch agency does their job. She claims authority over this based on the order she's already issued that the White House, of course, the executive branch objects to, that it's consistent with the TRO that I entered. She's claiming authority based on an authority-less order that she herself issued. The circular legal reasoning is unbelievable. It's my job to issue a TRO I have no authority to issue and then compel you to appear in my court to answer as to false accusations that you violated that TRO. That's all I'm doing, she says. That's all I'm doing. So I thought it might be a good idea. Is this every HR Karen you've ever had to deal with in your life? The manager from Office Space with the coffee mug? Remember that guy? Yeah, well, I thought it might be a good idea. We're going to need you to come in this weekend. I just thought it might be a good idea to go through the TRO because it may be what I've been seeing as a result of one of three things. What she's been seeing are propagandistic edited videos stripped of context provided her by the plaintiffs, obviously not unbiased sources, the media that are the plaintiffs in this suit. See, if this were on the legal merits, you know what would be happening? The media would be presenting their video, and then they'd be subject to cross-examination. And then the federal government could present the contextualized video, the rocks being thrown. But because this is preliminary, none of that is happening. This judge gets to look at the obviously biased, lying by omission evidence being presented by the plaintiffs, and then calling to task the Article 2 Executive Branch of Government, Gregory Bovino, Border Patrol Chief at Large, based on those lies. It may be that what I've been seeing is a result of one of three things. One is that the temporary restraining order just isn't clear about what agents can do and can't do when they're interacting with the public in the enforcement of the laws. Option 2 is that nobody ever read the TRO, which I don't think happened. And then option number 3 would be that folks read it and just actively chose not to abide by it. Given the fact that you, Bovino, and I took essentially the same oath, I know option number 3 is something that just wouldn't happen. You just didn't deliberately ignore my order, did you? So it must be option one, that the TRO is just not clear. Is that the only other option, Your Honor? Or is option number 4 that the TRO is perfectly clear, that Bovino is perfectly in compliance with it, and yet the plaintiffs are lying to you, and you're deliberately accepting those lies as true so you can chastise and micromanage the Article 2 branch of government? Is that another option that's on the table, Your Honor? Canadian born to Jamaican parents, lifetime appointed federal judge by Barack Obama? Is that another possibility? Because as it turns out, that's exactly what happened here. Paragraph 1 of the TRO. I don't know if I want to read all this. Let's see. It's ordered that Bovino and his officers are enjoined from dispersing, arresting, threatening to arrest, threatening or using physical force against any person they know is a journalist or should know. So what's that mean? Anybody embedded in this violent crowd who's got a press patch on, they fall into this category? Because it's not like people willing to use deadly force upon federal law enforcement wouldn't hide themselves as press, right? Unless the defendants, Bovino and his officers, have probable cause to believe the individual has committed a crime. Well, what about people in a crowd? If there's one person in the crowd shooting a gun at federal officers, they're not allowed to use group defensive measures like tear gas? Because you can't target tear gas at a specific individual? Defendants may order a journalist to change location, blah, 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 blah. So that essentially means that we've got to leave journalists alone. If they're doing their job, they need to be left alone to do their job. What if they're embedded in a violent mob? What then, Your Honor? What if they're not really journalists? What if they're just terrorists who put on a press badge? Because terrorists have never done that before, have they, Your Honor? Bovino and his officers are prohibited from issuing a crowd dispersal order requiring people to leave a public place they lawfully have a right to be, unless it's justified by exigent circumstances. Well, hasn't every order to disperse, show me the order to disperse that was not supported by exigent circumstances, Your Honor. It's never happened. The Department of Homeland Security Use of Force Manual defines exigent circumstances. An exigent situation for self-defense or the defense of others, they're authorized to use any available object or technique in a manner that's reasonable in light of the circumstances. When has this not happened? When has this been violated? Not one adjudicated example. Just lying claims from the lying liars who are the pro-illegal migrant media. Not subject to challenge, not argued on the merits in any court of law. Exigent circumstances are also a situation that demands unusual or immediate action that may allow law enforcement officers to circumvent usual procedures in order to preserve life or prevent catastrophic outcomes. You mean like rocks to the head, Your Honor? Like that? The judge then chooses to summarize this part of the TRO. And so, she says, folks on the sidewalk in the street, if they're in a public place that they lawfully have a right to be, they can be there, unless we've got exigent circumstances. Who's violating this? Nobody. For purposes of this order, a crowd dispersal order is a lawful command. Well, if it's a lawful command, what's the problem? When 3 or more persons are committing acts of disorderly conduct, is that not happening routinely? Show me the event where ICE or Border Patrol dispersed any kind of non-lethal weapon in the absence of disorderly conduct. Everyone's just going about their day, acting lawfully. There's no problems. And ICE just says, you know what? We're just going to throw out tear gas today. Again, the focus here is people that are committing acts of disorderly conduct that are likely to cause substantial harm in the immediate vicinity. So they're not just filming. They're not just standing there. They're not just shouting. None of that is anything that's going to cause substantial harm. But what if the people causing disorderly conduct and threatening substantial harm happen to be embedded with these people? What then, Your Honor? A long list of what these techniques are: riot control weapons, kinetic impact projectiles, OC spray, CS gas, blah, 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 everything. against a member of the press, a protester, or a religious practitioner who is not posing an immediate threat to the safety of law enforcement or officers. By this reasoning, no law enforcement officer would be legally privileged to use any area non-lethal defensive weapon like pepper spray or OC gas unless they could prove to this judge's satisfaction that every single person who might be affected by that gas is breaking the law. If there's one innocent person in that group, someone just wandering by on their way to buy a pack of smokes, and they get exposed to CS gas, Border Patrol has violated this TRO. Why would these area denial, non-lethal defensive tools even exist if this was the legal standard for use? Even a handheld canister of personal OC spray tends to affect everyone in the area, my friends. I've been there. And this is how the judge decides to paraphrase this part of her order. So kids dressed in Halloween costumes walking to a parade, they don't pose an immediate threat to the safety of law enforcement officers or others. They just don't. And you can't use riot control weapons against them. Who is claiming the legal privilege to use riot control weapons against kids going to a Halloween parade? No one is claiming that legal privilege. What's happening is violent protesters are embedding themselves amongst kids dressed in Halloween costumes, and officers are legally privileged to defend themselves against those violent protesters. And unfortunately, incidentally, those kids get exposed to the CS gas. Who is driving that exposure? It's not Border Patrol, who's acting lawfully in defending themselves against violent protesters. It's the violent protesters who are creating the necessity. But does Judge Sarah Ellis call them out? No. Are they in her courtroom, in the witness stand, being questioned by her? No. It's Border Patrol Chief at Large Gregory Bavino who's being subject to the chastisement of this tyrannical little Canadian-born to Jamaican parents federal judge. We're supposed to believe that Gregory Bavino is deliberately tear-gassing children dressed in Halloween costumes walking to a parade. That's what this judge wants us to believe is happening. Using riot control weapons at identified targets, if it's reasonably foreseeable that doing so could result in injury to the press, protesters, or religious practitioners who are not posing, these are the fake priests, of course, who are acting unlawfully, who are not posing an immediate threat to the safety of law enforcement unless such force is necessary to stop an immediate or serious threat of physical harm to a person. Like thrown rocks, like that. So using riot control weapons that may impact other people who are not posing a threat, you can't do it, Gregory Bavino, unless that force is necessary to stop an immediate and serious threat of physical harm to a person. When has tear gas been deployed by Border Patrol when these conditions were not met? When has this been proven in an adversarial process, not just accepting the demonstrably false claims of the media at face value? I'm well aware, Mr. Bavino, that things can be dynamic and change, and what may not look dangerous in one instance, a minute later can be very dangerous. And I also know I'm not there. I'm not out in the street. I'm here. But I'm getting videos that the plaintiffs file. Are they credible videos? Is there any reason to believe those videos might be stripped of context for adversarial advantage, for political purposes? I'm getting videos that citizens send in. And at least on the videos that I see, knowing that I'm not there, it's difficult for me to see that the force being used is necessary to stop an immediate and serious threat of physical harm to a person. Who judges this? Who controls and makes this determination? This is done in an adversarial process. You don't get to tell Border Patrol, you're not allowed to defend yourself because the media is saying you're doing it wrong. Firing CS or CN gas canisters, controlled noise, light distraction devices. The judge does not like it when Border Patrol uses flashlights, in self-defense. One of the violation reports, notice of violation reports, the plaintiffs, the media, filed here, indicated that someone was shot in the neck with pepper spray, with pepper balls. At least according to that individual. Any credibility assessment here? Any adversarial process? Any opportunity for the government to provide necessary context? We're supposed to believe that this was done with no legal justification. Why would we believe that? Why would this judge choose to believe patently biased parties here, the plaintiffs and the media, against the federal government that's speaking in this witness stand under oath? Is the media under oath here? Is the media being subject to questioning by the judge? Are these individuals who filed these reports, these civilians, these plaintiffs, are they being subject to cross-examination? That person, and again, this is what this person says, but that person says, I was not posing an immediate threat of causing serious bodily injury or death where the officer would be authorized to use deadly force. So we're just going to take them at their word? Why don't you bring them in and put them under oath, Your Honor? Why don't you have them subject to cross-examination?